This is really a wonderful, wonderful collaboration we've been undertaking for a number of years. And at the open house that we'll be having immediately after this, in which there will be free food and free alcohol down at the pub, and we encourage you all to come, I'll introduce, once again, not only our collaborators from CLBB, but our friends from the Harvard Medical School and many others who are here in the audience today. And we're really looking forward to that event as well. Our center has a big tent philosophy. We do forensic law and psychiatry. We do health law, and we do drug pricing. We do reproductive technology. We do it all. And we serve this community, not only the community of our students, but the greater Boston community, which is why we're so delighted to see so many people whose faces are familiar, but also some who are unfamiliar in this audience. And if this is your first acquaintance with the work we're doing, we hope it won't be your last acquaintance. And indeed, our next major event will be a book launch on a book on law, religion, and healthcare on September 27th at lunch here in the Wasserstein complex once again. Okay, that aside, I'm going to now introduce my good friend, my collaborator, the person who, when I was young and still, when I grow up, I want to be like, and that is Judy Edersheim.
Thank you so much, Glenn. Wow. I'm thrilled to be here. And the reason that the Center for Law, Brain, and Behavior is at Harvard Law School is because of Glenn and our wonderful collaboration with the Petrie-Flom Center. This is our 4th year, and this is a collaboration you'll find more about if you come to the open house later, and I urge you to do so. It's been a very fruitful collaboration. We have public symposia. Judge Nancy Gertner, who is in this office, is the primary teaching faculty member here at Harvard Law School for this initiative, and she teaches a wonderful seminar on applied neuroscience and law for this collaboration, and it really has been tremendously exciting. We teach judges, we teach prosecutors, we teach defense attorneys, we teach probation officers at the intersection of law and neuroscience, and there will be many interesting symposia. So please join our community, follow both of our websites. We do all kinds of interesting work at the intersection of law, neuroscience, psychiatry, and psychology. But today we have a really special treat, because this is the inaugural visit of our 3rd senior scholar in residence, Professor Francis Shen. So I want his introduction to be by the book. I can't introduce you to all of his work because it's too vast. We feel literally blessed to have him here this year, and we intend to take advantage of every minute that he's here. So Professor Shen is an associate professor of law and the McKnight Presidential Fellow at the University of Minnesota. He also has his own Shen Lab, so please log on if you're interested. He is, of course, affiliated faculty of the Petrie-Flom Center and of the Center for Law, Brain, and Behavior, but he is also the Executive Director of Education and Outreach for the MacArthur Law and Neuroscience Project, which is a very big deal. Francis received his JD from Harvard Law School, welcome home, and his PhD in government and social policy from Harvard as well. You're in for a real treat with today's lecture, because only someone who has a complete command of a field can tell you not just where it's been, but where it's going. And this is because Professor Shen is really one of the founders of this field, an intellectual founder of this field. He uses his knowledge of neuroscience to shed light on what are sometimes antiquated or misguided concepts of brain function enshrined in legal doctrine. So if you needed, in addition to my word, which of course is very good, if you needed proof of his preeminence in this field, he actually co-authored the only textbook in the field of law and neuroscience with Owen Jones and Jeff Shaw. So please, feel free to purchase it at full price, no discounts. So please join me in welcoming Francis Shen back to Harvard Law School.
Well, thank you, Judy. Thank you, Glenn. I want to start with a full round of thank yous. The Petrie-Flom Center has been a wonderful friend to me, not just this year, but in years previous. Thanks to Glenn, Carmel, and Chrissy. Thank you as well to Judge Gertner, Bruce Bryce here as well, Judy, and to Jess Patrick, who makes things go at the center. I'm really excited to be here for the year. I think we're going to get a lot of work done, and it's going to be a great time. I want to thank you as well for being here, and I do want to, there are a few seats up here in the front if you want to sit, but you're taking a bit of a flyer, because this is not something in criminal law or constitutional law, those tried and true subjects. This is something that most people have never heard of before, law and neuroscience, but I think you'll enjoy the ride. I'll introduce myself in a minute, but let's just start with some definitions. One, we know, revolution, noun, a major change, especially in ideas or method. So that's pretty good. That came from Webster's. So let's type in neurolaw to Webster's. Let's see what happens. Uh-oh. The word you've entered isn't in the dictionary. So we've got to start with the basic question, what is neurolaw? And it turns out this question actually isn't too hard to answer. And there are different versions. My view would be it's something like this: the legal use and governance of neuroscientific tools, concepts, and data. The basic idea is you're in law and you use neuroscience. And that's not unlike you're in law and you use sociology, or you're in law and you use economics. In that respect, there's really nothing amazing or special about law and neuroscience. What is it? That's not the tough question. The tough question is why. Why neurolaw? It's a little easier to understand why, at least now it's easier to understand why we have law and economics or law and sociology. But why law and neuroscience? These are two disciplines that have rarely spoken with one another. And my goal today is to convince you, or at least to have you consider the possibility that these two fields ought to go together, that they will go together, and that in fact in the long run they'll have a quite amazing relationship. So that'll be our journey today. By way of introduction, I run the Shen Neurolaw Lab at the University of Minnesota. Our motto, every story is a brain story, which I think is true, though the important caveat, which turns out to have legal implications and clinical implications, is that most every story is not a fully understood brain story. And we've got to work within that limitation. I have no disclosures. We go after grants, but I guess none of them are big enough yet to have a disclosure. I'm willing to change that. And I do want to just emphasize that if you're interested in the types of things we talk about today, visit the Center's website, the Center for Law, Brain, and Behavior. Visit Petrie-Flom. There's a large bibliography over at this other group that I work with, the MacArthur Foundation Research Network on Law and Neuroscience. As mentioned, I run our education and outreach activities. This group is based at Vanderbilt University. Owen Jones is the director, a wonderful law professor and director. And I run our engagement with judges and attorneys who want to come learn about, for those of you neuroscientists in the room, axons and dendrites and cell bodies. And you say to yourself, why would a judge want to learn about cell biology? Because it turns out that the judge every day is dealing with animals, happens to be the human animal made up of those cells, and the judges have been very receptive to that. So that's where I am coming from. You should already, I think, be able to tell I am always excited to talk about law and neuroscience. I mean, it's just, I love it. I'm especially excited to talk about it here at Harvard Law School, because it was here in 2004 that I had a transformative experience. I was a 1L in Professor David Rosenberg's torts class. And for those of you who are local, you'll know that Professor Rosenberg doesn't teach the traditional torts textbook, which is either great if you're me, not so great if you want to prepare for the bar, but I didn't care about that. I wanted the good stuff. And these were our first two slides. Here's slide number one, pretty simple, except that from the first moment, he wanted to emphasize the difference between the traditional formalist approach, the conventional way of doing law, and the functional approach. And here's slide two, where he told us why functionalism, the legal realist way to go about things, was the way to go. Now, this was his slide. I'm going to add on some color so you can see what caught my attention. He said, well, why does it matter? Because science provides the only way to think about these problems and solutions. He went on to say, as Professor Rosenberg could, and maybe a few of us can, science, not Ouija boards, to run the world. And that's the basic idea. To the extent that we have opportunities to draw on other bodies of knowledge, not just neuroscience, but science generally, we might help to aid law. And that, to me, is the wide neurolaw. Law is in the business of dealing with the human animal. And so if any body of knowledge, neuroscience or philosophy or English, can help us understand why we think the way we do, why we act the way we do, why sometimes we or others do not act or do not think the way we wish they would, then maybe that can give us some purchase on our jobs and help us do better law and policy. There's one other thing that Professor Rosenberg introduced me to, and I'm forever grateful for this. He introduced me to The Path of Law, and to all of us in the class, by Oliver Wendell Holmes. You may know this book, some of you. It was written in 1897. And in it, Holmes talked about his vision for the future of law. And this is part of, again, this legal realist movement, looking back at what they saw as the archaic formalism. We do things because we've always done them. And Holmes said the following. He said, the black-letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics. He went on to say, it is revolting to have no better a reason for a rule of law than it was so laid down at the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since. And his basic point was, let's look to other bodies of knowledge. He mentioned economics and statistics to inform law. Let's not just do things because we've always done it that way. Let's not just keep our assumptions because we've always assumed that. Let's learn. Well, was Holmes right? The answer is abundantly, in my view, yes. You just can look at this faculty. It's pretty widely recognized that law and economics has become the single most influential jurisprudential school in this country. And whether or not it's the single most, it surely is one of the most. There are PhD economists on this faculty. That would not have happened 100 years ago. So that's 1897, a prediction. It took about 100 years, but it came true. Here's my prediction for today. There's me. 2017. This is Brain Awareness Week, by the way, so I don't usually have human brains on a tray, but we were with fourth graders, so I was allowed to. Here's my prediction. Law and Neuroscience will become one of the most influential jurisprudential schools in the world. Am I right? I don't know. But I think I am, and that's what I'm going to spend the rest of the time doing, telling you why I think there's a future here for law and neuroscience. But before we get too far, we'll have to look back, so I'm going to start with one cautionary tale. There actually is a history of law and neuroscience. It's not so pretty, but we should learn from it. I'll then talk to you just a little bit about some of the current trends, and you'll see, I think, that all the trends point towards something happening pretty recently and pretty rapid. And then finally, I'll spend most of the time talking about the future, a version of Law and Neuroscience 2.0. So that's where we're headed. But let's start by looking backwards a bit. I wrote a paper last year called The Overlooked History of Neurolaw, and it surprised me. I had an inkling that, well, this can't be the first time that we've ever engaged with brain science as law and policy makers, and it turned out we weren't. I don't have the time to go through all of the details. I just want to pick one example, which I think is illustrative. And we'll start with the present. So this is a book published in 2013 by a colleague, I think a friend of some in the room, to me as well, named Adrian Raine. He's at the University of Pennsylvania. He's a neurocriminologist. And in this book, I won't go into the details, it's called The Anatomy of Violence. And his goal was to scan, and he did, scan a number of individuals who had committed murder and a number of control subjects. And his question was, can I see something different in the brains of those who murder as compared to those who don't? And what Dr. Raine was doing is something that law has been trying to wrestle with for a very long time. Why do some of us engage in interpersonal violence, sometimes to the point of killing one another? The point I want to make is that the very same question had been asked 40 years earlier. In 1973, two individuals, both here at Harvard, Vernon Mark and Frank Irwin, had, on the basis of a number of years of psychosurgery investigation, published a book called Violence in the Brain. And it made waves. It was in the New York Times, the LA Times. It was on the cover of Fortune magazine. Just the subheading, New Clues to the Causes of Violence. Scientists studying over-aggressive behavior are now implicating brain damage from hitherto hidden sources. Again, 1973. I'm going to show you a couple pictures of the studies they did. They're a little tough to look at, so I'll just preface it that way. There are studies that couldn't be done anymore, but they went like this in one of the local hospitals. They had patients who were coming in for seizure disorders, and they were doing deep brain stimulation to treat those disorders. Well, in addition to treating those disorders, the researchers thought maybe we can try and unpack violence and aggression in the brain. They focused a lot on the amygdala, and the idea was that we'll target the amygdala, we'll stimulate it, and we'll see what happens. And of course, they had altruistic motives, because law policy has this intractable problem. We can't seem to get some people from stopping their violent behavior. Is there a way that science could help us? So here's a picture of their most famous patient, patient Julia, figure 4. Julia in a pleasant mood before deep brain stimulation. That's what the DBS stands for. Then they press a button, they fire the amygdala, and there she is. Julia after DBS, rage behavior, attacking wall, suddenly and unexpectedly. Here's the point I want to make. Do you know how many times violence in the brain, again, what I just seemed to be completely on point, was cited in The Anatomy of Violence? 0 times. Why? I asked Adrian, I said, why didn't you cite that book or any of that literature? His response, I never read it, right? It had come and gone. Psychosurgery, there's an interesting social history, and it came and went. An iteration where we thought, boy, it sounded a lot like what I just promised you. We've got this great new neuroscience. These are Harvard professors, after all. We've got this intractable problem of law. Shouldn't we be able to find a solution? And we couldn't. We did not know enough about the aggressive and the violent brain. One more historical point on this same trajectory. Let's go back another 40 years. Now, this stamp is commemorative of the 1949 Nobel Prize given to Egas Moniz. Some of you may see on that stamp the little device for which he won that Nobel Prize. The device that would allow for prefrontal lobotomy. Again, earlier psychosurgery. Now, you have probably heard of the lobotomy. You're probably cringing a little bit. In hindsight, you think, yeah, that was not the best of ideas. But you probably didn't know that at the time, law was really interested in this too. I'm going to give you a quote from the 1948 Yale Law Journal. And I could have picked on Harvard or Stanford too, because they said the same thing. But we're here at HLS, so I'll quote Yale Law Journal. Here's what they said, quote, psychosurgery has startling implications for rehabilitation, and it is proving successful in an increasing number of cases. Perfection of so relatively simple and inexpensive a rehabilitative technique as the prefrontal lobotomy promises to be a major contribution to the cure of criminals, end quote. Now, thankfully, there was never widespread, or even too intense use of the prefrontal lobotomy in the criminal justice system. But you can see where things were going, and hopefully you get a sense of the tension. Because we, for the most part, in this building are lawyers, are policymakers. We've got to deal with legal and policy problems. We turn to science sometimes for answers, but we have to vet that science, whether it's admissibility in a courtroom or use in treatment. And we have to say, all right, science, what proof do you have that it's good enough? It's ready for prime time. So, in this case, I don't know. We have a Nobel Prize. And yet, even then, it was not ready for at least some uses. And so, I mention all of this not to be negative, but because clearly I think there's a future to this field, but to be humble about things. We have to recognize that the brain is the most complex organ in the body, and that the things that we care about as lawyers, cognition, decision-making, feelings, memory, are the most complex functions of that most complex organ, and proceeding humbly seems to me a wise thing to do. But proceed we will, and let's check out some current trends. So brain science seems to me everywhere. You can just look around on your bookshelves at the airport, and it's shown up in the courts. This is some data from Nita Farahani, a professor of law at Duke University Law School, and she has tracked criminal cases. I won't spend too much time on it now. I'm going to come back to this slide in a little bit. The basic idea is that you see a rise in the number of cases from the mid-2000s, and if that trend, the data continued to graph there, you'd see it, I think, continue to rise. So it's showing up in courts. It's showing up in legal scholarship. This is just a chart of the number of publications in the Law and Neuroscience bibliography that I mentioned before. I have a colleague who jokes that the implication of this is somewhere around the year 2042, every man, woman, and child in the United States will have published on Law and Neuroscience. Of course, I'm concerned about the flat line of this, right? Because we've already had it before. What's to say that we just go up a little bit more and we come right back down? What's to prevent that? Open question. Brain science is not just showing up in courtrooms, it's showing up in legislatures as well. The year before, I published a piece here in the Harvard Journal of Law and Technology called Neuro Legislation, and I tracked and coded all the neuro bills that have been introduced over the last 15 years. And again, you see, very similar to Nita's data, just this rise in the number since the early 2000s. Legislatures, what are they interested in? Well, you probably guessed it, Alzheimer's, brain injury, early childhood, healthcare, mental health, juvenile justice, sports concussions. But I want to make the point, just before we go further, that at least in this legislative data that I examined, it was not the case that neuroscience really rattled pre-existing normative commitments. That is, if you were on the left beforehand, you found neuroscience that supported your positions on the left. And if you were on the right on an issue, you found neuroscience that supported your positions on the right. An example of that would have called fetal pain-capable laws. They've been passed in a number of states, and this is the cutting edge of abortion litigation. It's also a law and neuroscience question. And if you read these bills, the argument is that, and again, the science is heavily debated, but the argument is that we now, based on neuroscience, again, based on the legislative findings of some of these states, we can say that the pre-viability, their fetus may be able to experience pain. Speculation, but speculation that in some of these states they've drawn on neuroscience. Now, those have been challenged and successfully so in court. I'm not here to talk about them. I simply want to point out that there's a vast array of ways that neuroscience may be used. Doesn't have to be left, doesn't have to be on the right, but it's showing up. It was mentioned before that Judge Gertner teaches a course here, which to me is indicative of, again, just the spread of this field. So you can take it if you're students, and I get to hang out with Judge Gertner in the spring. I'm looking forward to that. I want to just mention one other place where it's taught, where I'm also teaching as a visiting professor of neuroscience at Virginia Tech. This is an undergraduate course. And Virginia Tech is unique because they've created the country's first entire school of neuroscience. They started it just 2 years ago. They had 50 majors. They now have 550. They plan to get up to about 1,000. And in talking with the director, a neuroscientist, Harry Sontheimer, Dr. Sontheimer described it to me. He said, Francis, we want neuroscience to be the new English. So what do you mean by that? So most English majors don't major in English to become a poet laureate or write fiction. They major in English because they think they want to do a job where they need to learn to read and think critically and write. New English, his idea is that many of his students, they're not going to go to med school or PhD in neuroscience. They want to go into a job, maybe like law, where they have to govern and deal with human animals, and they want to know how that human animal works and thinks. And I'm teaching these kids right now, and I can tell you that some of them are going to be great attorneys and business folks. So we see this rise happening. I'll just mention our casebook, not to promote it, but to make this point. That in putting it together, we had to track down lots and lots of information. We didn't know actually at first if we would find enough. 86%, almost 90% of that material is just from the year 2000. It's when I graduated in college. 9 out of every 10 pages of stuff in that book didn't exist when I graduated college. 60% has just been published since 2008. I graduated the law school in 2006. Over half of the book didn't even exist. The stuff in there didn't even exist, hadn't been written. Cases hadn't been decided. Science hadn't been discovered. That's quickly moving. And already we published it in 2014. We need to do a second edition, revised edition, because it's already quickly becoming, in some ways, in need of that. There are many intersections of neuroscience and law. I'm not going to list them all, but any one of these things that I've listed here, I could give you some site, a case, a commentary, an ongoing dispute. It really is, I think, affecting a number of areas. How do we kind of think through this? Well, I'll give you, a few ideas. The big idea, and I think kind of the impetus behind so much interest here, is pretty straightforward. It might seem a little bit trite. I'm going to give you a quote from Owen Jones and my recent, just a little short 2-page paper. It's pretty simple, but a lot of law hinges on how brains work. And that's a pretty straightforward point, but I think it's also a pretty fundamental one. A lot in law hinges on how brains work. Now, as we go through, I'll give a little bit of a framework for how to think about this type of evidence. And this isn't, I'm not sold on these 3 tripartite categories, but I think they're at least useful for getting us going. So one is to think about regulation, the governance of neuroscience, both in society and in the courtroom. A second is, how do we use neuroscientific tools to aid law? And then a third, deeper, conceptually, doctrinally, how do we perhaps re-envision law through a neuroscientific lens? And you can do this in any area. I want to highlight just one for the moment because it's what I'll spend my year doing here at CLBB. We're going to look at the older brain, the aging brain, dementia, and the law. And you can go again to the website and see what we've got planned. And there are many examples in each of these categories. So regulation. What are the legal implications of a diagnosis of Alzheimer's? For instance, as soon as someone has a diagnosis, do you immediately revoke their driver's license? Yes or no? On what grounds? It's a very serious number of questions. Tools. Whether it's an individual in the courtroom or a group of individuals, how can brain scan data, which is now being rapidly introduced and integrated into clinical assessment of Alzheimer's and other types of dementia, how can that help and aid our assessment and definitions of capacity, competence, undue influence? And then conceptually, deeper, how do we reconcile law's insistence on categorical distinction with what surely the science is giving us as more probabilistic and non-categorical brains? How are we going to wrestle with that? We say things such as, oh, he either has Alzheimer's or he doesn't. That's what law likes to think. That's how we kind of talk. What about, I'll get to this in a little bit, a 45-year-old who goes in, has a brain scan, and receives, well, we can't tell you yes or no, but we're going to give you probabilistically, compare it to a normal brain, it would seem you have a higher than average risk. How much higher? Does it matter? Right? These sorts of questions, they're here and now. They're even deeper than that, and in a panel in November, right after the elections, we're going to run, including with, she's here, Dr. Rebecca Brendel, Bruce Price will be here, I'll moderate as well, a panel on dementia and democracy. We've got an aging demographic, we've got aging leaders in all three branches of the government. Does that matter for democracy? How would we know? And let's go back, think about tools for a second. Are there tools that we could use that might inform the way we evaluate these things? So we're going to spend the year thinking about these and related questions, but there's a lot else to think about too, and I want to talk about those now as we move into the future. So let me set it up this way. 10 years ago, and you probably didn't know this, but for those in our field, it was a big day because you open the New York Times Magazine, bang, Neurolaw's there. That's awesome. That's really cool. But 10 years later, it's been a decade, and where are we at? Right? What's happened? What's coming next? Recently published a piece that I'm going to draw on in these comments, Law and Neuroscience 2.0, and I think we're at a bit of an inflection point. It's not as if anybody knows about Law and Neuroscience yet, but within the field we do, and we've got to figure out what next. Where is neuroscience going to have some purchase? What is the future? I think the future is a balance of excitement and caution, and I'll tell you why. Why excitement and caution? So first of all, excitement, because let's start with that. I'm most excited by the fact that neuroscience isn't developing alone. And I want to emphasize this, that I don't think neuroscience is more important than genetics. I'm teaching a seminar right now on law and artificial intelligence. I don't think it's more important than our deep learning and robotics, virtual reality, advances in the biological science, computer science. I think these are all marching hand in hand. By the way, the same way that sociology and economics and political science marched hand in hand through most of the 20th century to develop their disciplines and their interdisciplinary work. This stuff is all coming, and neuroscience is a part of it. Neuroscience is continuing to grow. There's tons of investment in this area. This is a graph just of on the right-hand side, the millions of dollars being invested in neuroscience, and on the left, the number of people, the number of scientists who wake up every morning and try and discover the brain, and we are now over 50,000. And so I'm excited because it seems to me impossible to think that with 50,000 people and millions of dollars that we aren't going to learn a lot more about the brain. But we've got to be cautious, because what's the state of the clinical science? Stephen Hyman, the former provost here at Harvard, director of the Broad Institute, former director of the National Institute of Mental Health, asked in the years before the DSM-5 came out, can neuroscience be integrated into the DSM-5? And the logic was this. We know that mental disorders now are physically instantiated in the brain. That is, the brain enables those mental disorders. So in the same way that when we diagnose cancer, we take a cell biopsy, it's not symptom-based. You go and you do a scan. If you've got a broken femur, you don't say, how's your leg feeling? Okay, you probably have a broken femur. No, you go and get an x-ray, and it's when the x-ray comes back that you say, aha, look, I can show you where your bone is broken. Could we have something like that? Could we have biomarkers in DSM-5? Answer, not yet. So at present, despite all of the excitement, all of the investment in neuroscience, for the most part, in law and in clinical practice, we don't utilize neuroscience. And that's where things are. And because things are there and because it's so difficult, I subscribe to Gregory Miller, a psychologist, University of Illinois, to his view that intellectual modesty is in order. But nevertheless, I think there are ways that we're going to see some real innovations. Let me talk first about regulation. Both regulation of neuroscience in society, because it's showing up all over the place, and regulation in the courtroom. Let's talk about society, and here's the big question. By what criteria do you want to promote or criticize brain science in the public sphere? And I'm going to show you a little clip, just 30 seconds, of an advertisement that is typically run. This is a group that, well, it'll speak for itself. We'll just play it.
I worked hard to retire early, but I didn't want my brain to retire too. I mean, I stay active, but it's just not the same. Lumosity is real science disguised as games, so I enjoy doing it. It's a fun part of my day. My brain feels as good as ever, and it's way better than work.
Any brain can get better, and Lumosity.com can help. It's like a personal trainer for your brain, improving your performance with the science of neuroplasticity, but in a way that just feels like games. Start training with Lumosity.com right now and discover what your brain can do.
Discover what your brain can do. Sounds pretty good, right? Turns out there's an active debate amongst academics about whether playing such games actually gives you any lasting cognitive benefit or just makes you better at playing those games. This is, of course, a scientific question. It's a legal question, too, because we don't allow just folks to go out and say anything in the marketplace. And Lumosity said this so many times and in so many different ways that they were hit with an FTC fine. Brain training company pays $2 million over lack of demonstrable brain training. Now, if we had more time in this, for instance, a seminar, I'd then give you much harder cases, such as videos where we say 90% of a baby's brain develops in the first 5 years. And goes on to show this is a baby's brain on books, even though it doesn't look at all like a baby's brain on books, and even though that statistic may be a little suspect. But if it's to get kids to read books, shouldn't we encourage its use? Again, how do we evaluate the use of brain science? Let's go with another one that's coming, that has never been with us exactly this way before. We've been trying to enhance our brains since humans have been around. One way or another, education would be the primary way that we coerce it. So we take kids out of homes in this country at age 5, we force them into a room, and we manipulate their brains for 8 hours a day. And if you don't subscribe to that, we send truant officers after you to get those kids, put them in a room, and manipulate their brains. That's what we do. We call it education. It works really well for a lot of folks. There are also other ways to manipulate the brain. This was captured, it's my favorite, it should have been last year, but now I'll keep using it. By 2016, man's intelligence and intellect will be able to be increased by drugs and by linking human brains directly to computers. This is already happening in our sort of pill nation, but it's happening for enhancement, not just for return to normal. This headline captures it well. Minnesota high school students taking Adderall to boost academic performance. These are otherwise normal high school students without any diagnosis of ADHD who say, my natural self is actually a B+ student. I'm only getting Bs. In the same way that I might study harder or change my diet or go to the library more, I want to add a different way to manipulate my brain. And it happens to be in a pill form. It happens to be drugs. Do we encourage this or not? How would we distinguish this from those of you who wake up every morning and say, I'm not myself till I've had my first cup of drugs, also known as caffeine, right? But this sort of stuff is coming in new ways, and if we had more time, we could talk about the diagnostic, the mobile neurotechnology tools that are showing up. What about regulation in the courtroom? This is directly related to law, and we're seeing a number of cases that have the flavor of my brain made me do it, or my brain tumor made me do it. I'll give you just a few to give you a sense of what's going on. This is a man named Herbert Weinstein. Mr. Weinstein in the early 1990s was a New York ad executive. He strangled his wife, and then to make it look like a suicide, he threw her out the window of their 13th-story New York apartment building. The interesting thing for us is that, and he admitted all of that, but he wanted to use an insanity defense. And he wanted, in particular, to introduce this evidence. Now, you don't have to be a radiologist to see that in the upper right-hand part of both the MRI on the left and the PET scan on the right, there's something missing. And what's missing is our brain cells. There was a large arachnoid cyst pushing up against his frontal lobes. The issue that the judge had to do in terms of regulation was, should a jury be able to see this image? Of course, Mr. Weinstein can have his insanity defense, and of course his experts can testify, but should jurors be able to see images like this? Can they handle it? Does this image tell us anything about whether or not Mr. Weinstein actually understood right from wrong in those moments when he strangled his wife and threw her out their building? We're seeing a lot of cases like this. That was 1991. Here's 2017. This was a mixed martial arts fighter. Doctor says War Machine's brain injury could cause animalistic behavior. Was that the reason that he hurt his girlfriend or not? Open questions. You might say to yourself, well, I don't really know if any of this is ever going to sway anyone. I'll just look at the other fact. Would brain data ever matter? Answer, anecdotally, yes. This is Grady Nelson. Mr. Nelson was on death row in Florida. The facts of his case were horrendous. He stabbed his wife over 70 times, killing her. He attempted to stab and kill his two stepchildren. Thankfully, they lived. He had an additional history of sexual assault, rape. The list went on, and at the guilt phase, there was no question that he was going to be found guilty. But his attorney, Terry Lenneman, who I've met and talked with, was always thinking about the sentencing phase. Florida is a state where the death penalty is available. The prosecutors sought it. And the 12 members of the jury had to decide, is Mr. Nelson going to have life without the possibility of parole, or does he get the death penalty? And it was this evidence on the far right, something called something derived from quantitative electroencephalography, a fancy way of saying, let's measure the electrical activity in Mr. Nelson's brain. It's an expert named Dr. Robert Thatcher who testified that there were various abnormalities In the layman's terms, what Terry Lenneman said, and this was his quote to the jury, "Ladies and gentlemen of the jury, my client has a broken brain. It does not excuse his actions, but it explains it." Well, it turns out that that brain image was very powerful. We don't usually get a sense of what jurors think, but in this case, 3 of them spoke with the media afterwards, and I'll give you their direct quotes. Juror Dolores Cannon, a hospital secretary, quote, "When the brain evidence came in, the facts about the QEEG, some of us changed our mind," end quote. Next, juror John Howard, an airport fleet services worker. Quote, "The QEEG evidence turned my decision all the way around. The technology really swayed me. After seeing the brain scans, I was convinced this guy had some sort of brain problem," end quote. Juror Leon Benbow, a retired mailman, quote, because not everybody bought it, quote, "All that scientific testimony, that was a waste of taxpayer money. That's phony. There's nothing wrong with that guy's brain," end quote. I'm on record as saying that this evidence shouldn't have been admitted for a variety of reasons. But if I were counsel in the case and I were defending Mr. Nelson, of course, I'd have a different view. And indeed, it's an open question about whether or not it would be ineffective assistance of counsel in some cases not to pursue such a line of defense if, as is likely to be the case, some of this brain imaging becomes more readily available. In the same way you could go down the street and get a psych exam, you could get some of this information. Let me give you just a couple of more of the flavorful cases. We've always tried to be able to detect lies. There are some who've been tried to use neuroscience to detect lies. And this was a case, an actual case, where there was a 2-day evidentiary hearing about whether or not fMRI-based functional magnetic resonance imaging lie detection evidence should be allowed into a courtroom. This individual here that you see is a man named Lawrence Semrau. He ran a Medicare, Medicaid company down in Tennessee, and he had a pretty sweet system worked out. The way it typically works is you give some services, then you send a bill to the government. Well, they just happened to send billing codes every time that meant more in reimbursements, and the government had all these billing codes. They had them dead to rights. His argument, however, turned on his mens rea. In order to be guilty, they had to show that he did this knowingly, that he knowingly devised a scheme, and he argued it was just a mistake. It's really confusing. We didn't know how to do it. We called the 800 number, and so forth. Now, that's not unusual. There are others who claim that defense. What's unusual is that he found an expert to testify him named Stephen Lakin. I've sat down actually on this campus with Steve Lakin for a couple hours. I'll give you his side of the story, again, even though I'm on record as saying that this evidence should not have been admitted, and it wasn't. But here's what Steve Lakin wanted to testify. In my professional opinion, I, Dr. Stephen Lakin, conclude that Dr. Semrau's brain indicates he is telling the truth in regards to not cheating or defrauding the government. And right here in Massachusetts, he brought this defendant out. He lied him in a MRI scanner. He asked him a bunch of questions. He asked him a bunch of control questions. He said he had a system worked out. Again, I think it's very problematic, but he said he had it worked out. And as a result of all of his tests and his brain imaging, Dr. Lakin wanted to testify. Law has to regulate this. Do we allow jurors to see this? If Dr. Lakin were here right now, given the benefit of the doubt, here's what he'd say. There are 2 things you worry about in law: admissibility and then weight. Let the jury see it. In the same way that if 3 people see an auto accident, near, middle, and far, you don't tell that person far away you can't testify. You let them testify, and you just weight it less. You say, I don't know if that's so strong. Now, again, I think there are problems, but the point is that this evidence is showing up. It's actually people are trying to admit it in court cases. Let's go back to this. Again, I kind of want to sum up with the cases with these last few slides. There's this trend. We're seeing more of these cases. But this graph is misleading in a couple of ways. It's misleading, not that Nita's misleading, but it's just interpreting. It's easy to misinterpret. On the left-hand side, there are small numbers, but I'll tell you that the top number is 350. It's the number of cases. Now, this undercounts cases because they're not all reported. But even if it undercounted cases by a factor of 100, the denominator of all criminal cases in the United States is so huge that even at that level, neuroscientific evidence would only reach an infinitesimally small percentage of cases. Moreover, a lot of the evidence in here is not brain imaging evidence. It's actually behavioral evidence, sort of with some speculation about brain function. So where are we going with this? Well, I've written, I think that neuroscientific evidence might be a lot like instant replay. So the vast majority of plays in a football game or a soccer or a basketball game are not replayed. But when the stakes are really high, when it's a scoring play, when the foot is just on the line, and crucially, when you don't trust the call that the referee made on the field, you go to the replay booth. An image like this didn't exist 60 years ago. Why? Because the technology didn't exist. And in the same way, images like this didn't exist and were not possible for courts even several decades ago. They are now, and I think we might see them used, not all the time, but importantly at moments that are especially critical for law. All right, that's some of the regulation side. What about tools? This, to me, are some of the most challenging things to figure out. So I'll just mention a couple. We're working on memory recognition. What if I told you that you could walk into a lab right now, many labs across the country, they train you up on certain words or certain images, then they'd put you a little skull cap on that looks like this, and just based on your brain data, they'd show you words they hadn't shown you, so new things and things you recognize. Or what if I just showed you picture of your mom? Immediately, you would recognize your mom, but even if you didn't say anything, they would be able to use brain activity to figure out that you are seeing something you recognize. Does this have forensic use? Maybe. We're exploring it. Not yet, but maybe. I want to say that this is a headline about our story. New neurotech might be perfect evidence for courtroom use, study shows. No, it will never be perfect, but it might be evidence. Right? It might be evidence someday. We'll have to see. I would just want to mention pain. I won't talk about it at length, but I want to flag the fact that our colleague Amanda Postilnik, the first senior fellow in applied law and neuroscience here at CLBB, is leading a massive effort on pain neuroimaging. Why is that important? Because chronic pain in the law is still so contested, because our measure of pain still right now is a set of smiley faces, and this is challenging for law. Here's what I want to talk about, what I think is maybe the most important frontier, biomarkers. There's great uncertainty ahead, and it's this question: how should the law handle probabilistic biomarkers of mental disorder? To date, the law has almost always taken the things that we can see, combined with the self-report, what you can tell us, and they'd made some guess about what's going on inside the brain. Most brain injury is diagnosed without any cellular data. You do a bunch of neuropsych testing, and then you guess, well, there's a memory deficit, so there's probably something wrong in this circuit. We go from behavior and make a guess about the brain. What's starting to happen is that we're taking brain data and making a guess about behavior. I'll give you two examples from the ends of the life spectrum. What are the legal implications of early detection of elevated risk for Alzheimer's disease? 45-year-old person, 40-year-old person, no clinical symptoms. It's not even the early signs, nothing. They are fully functioning, but we're seeing changes in brain activity that suggest probabilistically that they may have a higher risk for developing Alzheimer's or some other sort of dementia. We've written on that, and here are some of the questions that are challenging for law. Is that a legally relevant brain state? I mean, what do you do with that? Because you're fine. Again, all the indicators that law usually cares about, everything you tell us, you feel fine, you look fine, you're working fine, doesn't seem like a disability. So can I discriminate against you? Well, maybe there's some in the ADA that would say no, but it's an open question. What about evidentiary challenges? What about insurance? What if your doctor says, well, there are a whole bunch of things we could start doing for you, and you say, yeah, great, well, I want my insurance to start paying for that. And your insurance says, well, you're healthy. Do you feel fine? Yeah, I feel fine. Take every single battery of behavioral tests. Your memory works, everything's fine. Is that legally relevant? And who should have access to that data? Right? And how early should we tell? This kind of stuff is showing up. Here's a company that thankfully doesn't exist in the market anymore, but did. It was called Mind Genesis, and here's what they wanted you to come do. Our goal is to provide the comprehensive and definitive imaging services required for confirming the presence or absence of Alzheimer's disease at the earliest point possible. Law regulates groups like this. Again, what are we going to do? It's here. It never has been before. We can ask this question really for all sorts of things. I'm just going to do one more fill in the blank. I think it's especially challenging for us to think about. What are the legal implications of early detection of elevated risk for autism spectrum disorder? There's a national, actually an international group. One of my colleagues at the University of Minnesota is helping to lead it. And what they do are take little 6-year-old toddlers, little 6-year-old babies. Now, you can't tell a lot about, excuse me, not 6-year-old, 6-month-year-old babies. You can't tell much at 6 months. I mean, maybe you have some intuition, but they take them, they put them into a brain scanner. There's the specially designed child brain scanner. They scan their brains. In research, they have found that just based on that brain data, with 80% accuracy, they can identify which of those kids will go on to develop and be on the autism spectrum disorder. They're doing their second 5-year study now, a follow-up study funded by NIH. They think they'll get that accuracy up even further. What do you do with that information? That's a challenging issue for law. Special education implications, ethical implications. Again, we're taking brain data and making a guess about behavior. We have never been able to do that before. Is law ready to handle it? Finally, some concepts, some deeper issues. Applying a neuroscientific lens to law sometimes is more than just here's a neuroscientific tool. We can do a little bit of adjudication better. It's sometimes about sitting back, understanding, changing our perspectives. This has happened in a lot of areas. It's happening already. Notably, and again, work that the Center is doing in juvenile justice. There have been a series of U.S. Supreme Court decisions where our U.S. Supreme Court has cited to neuroscience, and where neuroscientists have directly entered the legal process by submitting briefs talking about the developing brain. They're changing conversation. There are now discussions about raising the age from 18 to maybe 21 or even 25 for our juvenile and adult system. There are new young adult courts showing up, changing perspectives. We might have also changed perspectives on mens rea, criminal mental states. I wish I had more time to talk about it. I don't. I just want to say that I love mens rea, and I've written a lot about it. I just love it. But I want to, in our last few minutes, talk about this, because I think it's really deep. For a neuroscientist, saying that there's some sort of mind out there that isn't enabled by the physical brain is anathema. It just doesn't make sense to them. Yet for the law and for many of us, we still subscribe to what philosophers would call substance-use dualism. That is, we sort of think there are two substances. There's the brain, and then there's the mind, and they're two different things. And so we talk about mental and physical disorders, or mental and physical injuries. And it turns out that this is pervasive in law and matters all over the place. In fact, if you have any of you drive and you have auto insurance, you have bodily injury coverage. So here's a case that really brings this into perspective. We're going to go to Bloomfield Hills, Michigan. It's one of my favorite cases in all of neurolaw. And this is not a picture of the actual accident, but it captures exactly what happened. We're going to be interested in the conductor in this train. His name is Charles Allen. He's coming down the tracks when suddenly and very negligently, here's the car, ding, 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 ding. For some reason, this Bloomfield Hills school bus driver swerves out and decides he's going to try and put pedal to the metal and get past the train. Bad idea. Very bad idea. Thankfully, there are no kids on the train, but Charles Allen can't stop, and he crashes into the bus. Okay? Now, you can imagine, put yourself in a position. You think you've just killed a busload of school children. He runs out. Again, he runs out with nary a scratch because he's in the big train. He sees that, thankfully, there aren't kids killed, but seriously injured is the driver. Fast forward. He goes on to develop post-traumatic stress disorder. Everyone in the case agrees he has PTSD. Everyone in the case also agrees that this PTSD was caused by this amazingly traumatic event. Here is the legal question. Can he sue the city of Bloomfield Hills, the state of Michigan? Now, this just takes us, we've got to add one layer of law on here. There are, in many cases, and in this case, a government immunity statute. And for a variety of policy reasons, we hold that individuals often can't sue the government. But there are exceptions to that. And Michigan, like many states, has a bodily injury exception. Here's how it reads. Government agencies shall be liable for bodily injury and property damage resulting from this negligent operation. So to clarify, if Mr. Allen had just been walking down the tracks and he got hit and he has a broken femur, he can certainly sue. But that's not our Mr. Allen. Our Mr. Allen doesn't have a scratch. His legs work fine. His heart works fine. Everything works fine except he has PTSD. He brings a brain expert in to testify. His argument to the district court is that PTSD is a brain injury. It's mental. It's the brain physically enables the mind. It must be physical. District court says, in a classic slippery slope fashion, whoa, are you saying that if that's physical, then isn't every mental disorder physical? Well, that's the point, but yes. And they say, we're not going to go that far. We're the district court. We can't do that. Goes up to the Michigan Appellate Court. Appellate Court says, we see the logic of your argument. The brain is a physical part of the body. PTSD, and supported by your brain imaging, is physical. We're going to allow this suit to go through, and it went up to the Michigan Supreme Court. There were amicus briefs from the plaintiff's bar, from insurance, and it settled. So we don't know what the law is in Michigan, but these cases are arising. It arose in Minnesota in another tragic case. There was a big school shooting before I got to Minnesota. Some teachers were, and I'm going to put this in quotes, physically injured because they were shot or they fell down. Other teachers saw their colleagues and their students hurt and killed and developed PTSD. They all applied for workers' compensation for some of the time they couldn't show up. And the courts in Minnesota split as to whether or not that PTSD was a physical injury. The way the law was written at the time, it had to be physical for them to recover. So this stuff is showing up. I've written on it. I'm going to, in the interest of time, push through it. But I'll simply say that we don't know whether a lot of stuff. I'll give you one slide. You can guess yourself. So I asked a bunch. I do a lot of empirical work, and I asked a bunch of subjects. Think about these things: broken leg, broken ribs, concussion, sprained wrist, little torn lung tissue, scratch, memory loss, recurring headaches, PTSD, depression. Are you 5 definitely bodily injury, one definitely not bodily injury, or somewhere in between. Do you know can you figure out for yourself what bodily injury is? And they're all over the place with these middle ones. Memory loss, recurring headaches, PTSD. Some folks think it's definitely a bodily injury, some don't. Turns out that in law, we've done further experiments, you can manipulate this and this is law's choice. Law can define what bodily injury is, and if you include brain data, you can get up to 71% to say that it is bodily. If you really restrict it, you can push it back. My point is simply that the law intersects with neuroscience, but the law controls a lot here. We get to define those things. Neuroscience will increasingly challenge some of our definitions, but we can stick our head in the sand if we want to. So let me give you my final ruminations on the future. And I'm going to use our HLS 200 theme because every sign around here is HLS 200. But what was life like around here at HLS 100? Well, I gave you the sense from Justice Holmes. 100 years ago, this was a place of black letter law. By the way, there was also a place of, it wasn't a mistake when he said the man, right? A lot of other things have changed, but it was a place of black letter law. HLS 200, today, law and social sciences abound. There are a minority of this faculty now who don't seriously engage with some of the social sciences, whether it's history, sociology, economics, political science, critical studies. Let's fast forward one more time. HLS 300. 100 years from now, what do you imagine? And can we imagine a neurolaw revolution? So I think we can. I'm excited about the journey. I don't think that we're there yet by any means, but I think we'll get there. And my last reflection is really just on how we get there. I guess if we get there at all. And I do not think it will happen from broad pronouncements. It's not going to happen from these sort of best-selling self-help gurus who are on TV. It is going to happen in rooms like this, and it is already happening, because I'm in them a lot, in rooms like this. The future of the field is based on neuroscientists who are willing to ask really tough questions and go after and answer them, like so many of our colleagues in the room. The future of our field, frankly, is in the hands of our students, and it's really neat to see so many of you here. So let me give you this final quote to mull over. Bill Gates has said that just in general about technological change, we often overestimate how much change there will be in 2 years, while we often underestimate how much change there will be in 10. We overestimate the short gain, and we kind of miss what's slowly happening. And I think the spirit of that, maybe not the number of years, but the spirit of that captures neurolaw very well. The neurolaw revolution will not show up all at once. 2, maybe even 5 years from now, an outsider who looks in will see nothing that looks any different from now. But the insiders, and now I include you, you are an insider, you know the real deal, the insiders know that the picture is slowly looking different. And what I submit to you today is that signs of a neurolaw revolution are already with us. Thank you, and I look forward to your questions.
So we're now going to have questions. Before I do, I just want to acknowledge 2 people who helped put this event on together. Christy, as you're walking, you can wave. Christy Hutchison-Jones, our executive director. Is Justin still in the room? Where is he? There's Justin Leahy, also on our staff. And we also want to let you know, if you're not already on our listserv, there is a sign-up sheet outside. We encourage you to do that. If you've got a question, you can line up right here. Questions should be questions. They should be relatively short. And to model that, I'm going to ask a relatively short question. Francis, thank you for a wonderful talk. On the point about dualism, which I found very interesting, doesn't strike me as real dualism. It strikes me as damages dualism, and really much more analogous to, let's say, Martha Chamalis's work on how injuries to women were viewed in tort law, right? So it's not a metaphysical endorsement of dualism. I'm curious whether you disagree with that, whether you think this is a deep dualism.
I agree and disagree. I think it is probably in its first layer best understood as a pragmatic response. I doubt that the district court judge was thinking deeply about any philosophy or neuroscience and was just thinking about a slippery slope. Whatever reason, if I label this, you can recover, a lot of other people are going to sue, I don't want that result. But I think it actually is one of a collection of cases and commentaries that are starting to grapple with this. And I think what we're going to see is that law can hold on to this distinction, but it will become increasingly distanced from what the empirical reality is, which is okay. We have lots of other legal fictions. And if we think, and if we want to justify our legal fictions on some other grounds, for instance, some pragmatic grounds or some efficiency grounds, I think that's okay. In fact, I've said as much, but I think we ought to be very transparent about that and articulate that. And to the extent that whether it's just clothing on top of our real reasons or it's more deep, we have got to do away with this notion that the mind is something other than something that's physically enabled, though we don't know how, by the brain.
My work involves health records, and in particular how licensed professionals, physicians, interact with an individual's health records, and how a law professional, a lawyer, could interact with factual information in a health record. And you glossed over very quickly, not a criticism, over sort of the issue of who owns that data and who has access to that data as it becomes more and more interesting as a biomarker, for example. What can you say about these professional relationships around the data collection process?
Great question. Thank you for asking. It gives me an opportunity to talk about privacy issues. So both in the situation I had you imagine, where an individual goes into a clinic, has some data collected, and that data may be potentially relevant to their health, but also potentially damaging to something else they care about, for instance, their job or their relationships. Both that and the use of mobile neurotechnology, which I didn't have really a chance to talk about, which is really the future of a lot of this technology, are collecting data. It's unique, I think. It's both unique and not unique. It's not unique in the sense that we collect a lot of other data. Someone goes in for a blood draw to see whether or not they have a certain sexually transmitted disease. We need to, and we've got things in place to keep that. I think this is, so I think we have to be very cognizant of those privacy issues. I think it's really challenging because we don't know what to do with the probabilistic data. And that's, I think, the distinction that, and I'm wrestling with exactly what to do with it. And the reason that I think the probabilistic nature of the data is so relevant is that, you know, these yes-no answers are in some ways a little bit easier to deal with. They're potentially damaging. To say that someone has a risk is no more to say than we all have a certain risk of something. I mean, being born, we've got, you know, and based on our genetics and something else, we've got a certain risk of stuff. That in and of itself isn't problematic. But whether or not the brain data is special, I think is an open question. We haven't wrestled with it yet. There are a lot of people trying to think about it, and especially in this context of mobile neurotechnology. What I mean by that is wearing a little device here that's going to read data in real time. It's happening in Cambridge, by the way. A group at MIT has outfitted bike helmets with a little EEG recorder right here. It allows, and it works with your smartphone, allows a couple things to happen. One is for the individual riders, kind of beeps and lets them know when they're getting in a stressful situation. They kind of become more cognizant. And two, they're aggregating this data. Here's the privacy issue. And they can imagine using it when they get one of these turnarounds, not that Mass Ave ever gets a little crazy out there, and say, hey, City of Cambridge, you know, every morning about 8:45, we're seeing a massive spike in our bikers' stress levels. Can we redesign this area? That's on one hand great. That's on another hand scary, because what else could we use that data for, and how do we protect that? And I think those are open, unanswered questions.
Hi. I guess my question is where you can draw a line, or how law can draw a line, because there's many cases, the obvious thing of the tumor, prefrontal cortex influence your decisions, or a lesion in amygdala, but you can have cases of an abusive childhood, and that definitely changes neuromodulators being released in the brain and the behavior of this person. Especially nowadays, we know more and more that what happens to the parents actually ends up influencing the nervous system of their kids. So where do you draw the line? Where can you go back and say this person is doing this because it happened this when they were young?
Yeah, so it's a great question, and I should clarify that in general, explanation is not excuse in the criminal law. Even if you got a great explanation, it's not an excuse. Why did you break in and steal a loaf of bread? Because, you know, someone was starving? You're still guilty of the crime. Why did you do these things? Because you were raised in a horrible environment, because you got the bad lottery on genes, because all these things. Typically, that's not an excuse. We've seen, and it's an opportunity to say, more of the neuroscience at present having an impact at sentencing. So not affecting whether or not you're guilty or not, but at that point saying, all right, you're in the system, we've got to do something with you. Can the things we know about you, now potentially including what we know about your brain history, your trauma history, your abuse history, can we do something different with by the way, your addiction or not? And I'll highlight again the work that the center is doing. They have brought here to Harvard Law School groups of judges, probation, DAs, defense, to, as a group, try and problem solve, not on the question of are you guilty or not? Did your brain make you do it? You say, all right, you're going to be found guilty based on current doctrine by and large. But you're coming into the system. We all are better off if we can do something to improve your outcomes. And is there something that brain science can add? And I mean, the skeptical version is right now we might be really limited. We might be really limited because we still can't reduce our suicide rate. We can recognize, but we're struggling to address our opioid addiction. So we're waiting our neuroscience to give some answers. But the conversations are starting, and it's been more at the sentencing, kind of what do we do in treatment, as opposed to any fundamental shift, and we're now going to say that these individuals aren't criminally responsible.
Oh, this is really raising somewhat the same question that was previously raised. You mentioned in ASI that you love mens rea. Isn't there a danger, and you're talking about the present situation, but isn't there a danger that the progress of neuroscience will gradually erode the concept of mens rea and the concept of responsibility in general? The more things you discover are due to brain structure or brain deformation, the fewer things become properly, don't come into the category of something for which you are responsible. You're saying that that's the way it is now because you don't know very much, but...
Great question. So, and you're thinking like many theorists in our field. There have been a couple of seminal papers. One of them was The Criminal Justice System in the Prefrontal Cortex, written by Robert Sapolsky, who's a neuroscientist. He made the following analogy. He said, if the brakes on your car break, you deal with them almost immediately, but you don't moralize about it. You don't say, bad brakes, why did you choose to brake? If you can't fix the brake, if it's really broken, you don't put that car back on the road. Those are your options. And he said, it may sound kind of callous, but in fact, that's what we ought to do with our criminal justice system. We ought to have one. It ought to be purely utilitarian and consequentialist. It ought to give up entirely on the idea that someone has chosen. Because in the same way that, here's my watch, it ended up there. My watch didn't choose to end up there, given the laws of physics, the way that I held it. Once I let go, if you knew all the parameters, you would know exactly where my watch went. There are many in the neuroscience community who subscribe to that view, and they don't. The implication for many of them is not anarchy. It's not we all give up hope. We're predetermined. It's that we reform criminal justice in light of those findings, and in large part we do away with the sort of the moralizing that goes along with it, and have a pure utilitarian approach. And the other, actually a colleague here, Joshua Green in psychology, has written this paper for neuroscience, for the law. Neuroscience changes everything and nothing, and you've hit on the change everything part. It's very challenging.
Hi, good afternoon. Can you expound more on how Neurolaw can help on with contracts? For example, like elders signing an overpriced home improvement contract, and then there's a concerned family member who discovers that after the fact.
Yeah, great question. And I love that you say we've discovered it after the fact. So the first case in our casebook concerns exactly this situation. It's for sale of land, and the individual who's selling the land is older. And the legal question is whether or not, at the moment of contract formation, he had the requisite capacity. And it's after the fact that they get some brain data, and they introduce this brain data. And I actually had a student who published a note raising the challenge of the temporal challenge here. Because law, understandably, is doctrine that says we can have these moments of clarities. We care only about that moment of contract formation. And can it ever, unless you're going to be signing while miraculously in a brain scanner that would seem to be taking measurements of your capacity, that's never going to happen. And so it's always going to be something later, typically. Maybe before, but typically later. Can that data ever be relevant to the decision before? Well, there is case law that says yes. And that's actually true for non-neuroscience data as well, behavioral testing. It's one of the things we'll think about this year at the center as to whether that should be relevant and under what conditions. My view at present, we haven't published on it yet, is that there are conditions in which it would be relevant. It would never be dispositive, and that there are also conditions under which it would not be relevant. I know that sounds like a middle-of-the-road answer, but I think that's the case. But I do think it's the case that there might be some times where you would say, at an extreme, even though we took this data, whether it's behavioral brain, 3 days later, we're pretty confident that 5 days before, when this contract was signed, the brain wasn't functioning any better. And I think there's probably some other moments when we say, you know what, there might well have been some fluctuation, and probably my view would be that we have a default rule to enforce that contract in those cases. But those are the types of flavor of things, and this temporal issue you've raised is a real challenge.
This is sort of a general question, but are you ever concerned that the word neurolaw in and of itself confers a certain aura that predisposes people to kind of assign more gravitas to the field than it otherwise deserves? I'm from psychology, and we deal with this issue where if you put a picture of a brain on one of your journalistic studies, it automatically predisposes people to think that that's more of a scientifically grounded study than another might be. When you have, for example, like cognitive heuristics, which bias people towards certain types of behavior in much more of a certain way than I would say certain brain studies show us to be predisposed to certain behavior. So the whole idea of neurolaw, if you were to kind of, I don't know, reassign the label in a certain sense, saying that we have behavioral studies that don't have to deal with the whole black box of the brain, but that nonetheless touch on what the brain actually makes the body do. Do you think that might actually kind of heal some of the wounds that, so you touched on it earlier by showing, talking about what types of evidence are admissible. If you're just showing a brain scan, right, kind of providing the anatomical coordinates of certain types of behavior in the brain doesn't really tell you about those behaviors, the risk factors associated. So how do you deal with that aspect of neurolaw in general?
Try to deal with it head on. So we just wrote a paper where we reviewed this literature and tried to look at it. And the literature says what you suggest it does. No one knows exactly why, but for some variety of reasons, in some contexts, though not all, and it's kind of contingent, so we had a context where it didn't matter, introducing either brain images or brain talk can affect either the rating of a scientific article, the outcome of a legal case. Clearly, and they're paid to make money. Those people who are marketing for Lumosity think there's some reason that they should keep talking about the science of neuroplasticity. I don't know how many times I said neuro or brain, but it's a lot. So I think it's an open question about why it's happening, but it is potentially happening. I do think, and we've had this conversation around the dinner table, kind of these meetings and stuff. What if it hadn't been neurolaw, but just some sort of other law and something? I do think there's something to it. And I think that the most important thing we can do is be intellectually modest. And so that one slide is from Greg Mitchell, and his point is that for most of the things right now that law cares about, neuroscience really doesn't help us much at all. And in fact, many of the things that have been labeled neuroscience and law are not neuroscience and law. An example would be eyewitness memory. Now, you have a series of things. There's a tremendous amount of great work, psychological work on the fallibility of eyewitness memory. You've had law responding. You've also, at the same time, had a bunch of tons and tons of neuroscience work on the neuroscience of memory. But the stuff that's really mattered for law has been the behavioral work. And that's going to be the case, which is why I've tried to emphasize, and I think the future has got to be those places where even the best psychology doesn't do what neuroscience does. And everyone, I think they can have their place. It's not to supplant psychology. It's not to supplant the social sciences. To me, it's to put broadly the natural sciences, including all those other fields, at the table. It's striking that we have as many PhDs. I didn't do this, but look at the faculty here. PhDs in social sciences. There are a lot of them. PhDs in natural sciences. There are a few. Why is that, and will that change in 100 years? And I think it will, and I think that'd be a good thing. We'll see.
So I was just wondering, following up on that, sort of how long you project it will take for us to have the machinery to say, oh, this EEG we can say is actually an accurate representation versus a person having caffeine, or these easily ways to manipulate the actual scans. And sorry if I missed that part earlier.
I think a very, very, very long time. And that's, to me, is going to be the challenge. So you're going to have advances that aren't dispositive, but they are informative. And it's the same thing with clinical medicine. So we make an advance. It's not dispositive, it's not curative, but it's a step in the direction. And I think law is going to have to decide at which point some of those advances and some of those incremental changes in science lead to changes in law. And some of them we might say we're not ready yet, and that might be the right answer. And there might be other times where we say in certain context, okay, we are going to reform things. And we'll do that, and that's, that really be our thought this year in the aging brain, where with dementia, it's one of the places where we are seeing the use of imaging, much more so than in some of the other mental disorders. And I think that's going to be very challenging for the law.
Hi, thank you. I'm approaching it sort of interdisciplinary as a clinical psychologist and neuroscientist, and who also does genomics and a bioethicist. So
a lot. That's great.
But one of the things, if we draw on each other, I think what we can learn is we're terrible with many forms of epilepsy, of looking at EEGs. We have a long way to go on that end, and from the behavioral end of when it's going to happen, the duration. And the same thing with genomics, that even when we have something concrete, we have a really hard time delineating what does it actually mean. And I think that that's one of the confounding factors that's really going to take a long time, is even if we can observe it in neuroscience, even when we see a scan, of really understanding what that means for intentionality.
I agree, and I think we're going to see an increasing divergence, and I think the autism is a great example of this, between our predictive ability, our functional ability to do something, and any idea of what the underlying neurobiological mechanism is. And that's going to be a real challenge. Because it's, imagine you've got a friend who's just able to predict the games. Every Sunday they predict every football game. And you ask, well, how you do it? I don't know, I just do it. What do we do with something like that? And we're going to get to that point where who knows exactly how the circuits are working together? We don't have a great story, but if it's working, it might work. And by the way, that's the way that a lot of drug trials work. You flood the brain with a bunch of chemicals, and the trial is not, let's look at the mechanism of action as much. I mean, that's an overstatement. But what we ultimately often care about is, are there perceived differences in whatever the health outcome is? And I think that could be kind of scary sometimes, yeah.
Hi, thank you for a great talk. So one of the things that this has sort of made me think of is in clinical medicine, for instance, you could have lab tests that point a completely opposite way from all the other evidence that points you to a specific diagnosis. So even if you have 3 or 4 indicators that match and then one indicator that doesn't, that one lab may point you in a different direction. I think similarly with brain scans or any other biological evidence, you have the opportunity for it to point in one direction, but symptomatology might go in a completely different direction. And so your behavior outcome will be completely different from what the biomarkers actually end up saying. So to what extent does the inclusion, do you think the inclusion of more of this neurolaw actually puts a burden on both the legal staff and also the jurors themselves to understand probability and statistics, and also some of the more complex thinking that is required of clinicians in order to accurately make treatment suggestions for patients?
It's a great question. I think I think you're right on point. I think that these issues, these moments where you see divergence between behavioral, clinical indicators and brain indicators, are the most contested for law. And we're seeing examples of this. We just ran a set of experiments based on this memory detection. These were mock jurors, and we set it up so that we wanted to get exactly what you were saying. So what if all the facts suggest that this guy did it, but then the brain scans suggest innocence, and vice versa? The guy's got an alibi, it seems like he didn't get it, but uh-oh, the brain test suggests he did. Would they be able to sort through all of that evidence and sort of, who knows what the proper sign, but at least not be completely foiled by the brain evidence? In our little mock jury studies, they did okay, but I think there are other instances where they might not be. And there's an ongoing case right now in brain death. It's not a topic I talked about here, but there's a lot of work. It's a young woman named Jahi McMath, and she's either alive or dead in California right now. We don't know. And the court has just opened up that case, and I think they're going to allow it to go to a jury. And part of the evidentiary burden is going to be the clinicians who say, because it's a wrongful death suit. So the idea is that and whether or not she's alive matters, clinicians are going to say, we did all of our clinical indicators. Dead, dead, dead. And the family is going to come up and say, we found some other doctors, by the way, who do this. We've run these brain imaging, alive, alive, alive. I don't know how we resolve those issues, but we're not great at statistics in law, so we have some work to do.
Hello, thank you for putting on the talk. I'm sorry they got here a little late, so hopefully this isn't treading over material you've already covered too much. But near the end, you referred to work by Sapolsky and Joshua Green arguing that neuroethics and neuroscience will ideally inform a more consequentialist and utilitarian approach to law. Well, so when I heard that, I thought to myself that those are actually two separate things, right? Consequentialism is a broader category of ethics, of which utilitarianism is one subset. And it kind of made me wonder, to what extent do you think neuroscience can or should supersede traditional philosophy in helping to figure out the scope and limits of legal theories of responsibility? Another example would be that it could be that we'll come to find that most actions that we think are voluntary are really materially based, or they come from some neural impulses, and we argue that the whole idea of free will is totally misplaced metaphysically and neurologically. But to many people, there might be some common sense standard that we recognize, right? Something like what a reasonable person would infer to be a form of voluntary action. Do you think we'll still be able to preserve those, or that some notion of common sense voluntary action will still be useful despite findings from neuroscience? Basically, do you think neuroscience research will lead to a kind of eliminativism in legal theory?
I don't think so. So my view on these questions of free will is that I'm not that interested in them. I'm glad that my colleagues are. They've spilled a lot of ink on them. My view is that even if we don't have free will, we need to act like it anyway. And my work, and I think, and others have written more elegantly, we've got a legal system that's dealing with massive numbers of individuals with addiction. We should deal with that. Whether they have free will or not, we need to make life better for them. We've got a rising number of older adults in the world and in the country. We ought to deal with that, whether they have free will or don't. So I think those are really important discussions to have. I think neuroscience does challenge some deeply held beliefs. I think the engagement of philosophy and neuroscience is important, and I've participated in these discussions. But my own view is if that defines our field going forward, we're in trouble.
Last chance for questions. Going once, going twice. Sold.